Yes.
May it please your lordships. I'm Mr. Froud. I appear on behalf of the Appellant local authority. I'm attended today by Mrs. Crowther, my instructing solicitor, and the allocated social worker. Learned friend Mr. Batt appears on behalf of the mother. The learned friend Miss Ellis appears on behalf of the respondent father, along with Miss Howarth, her instructing solicitor, and a pupil from her chambers. Both parents, my lords, sit at the back of court. My learned friend Miss McGrath appears on behalf of the child, acting through her children's guardian, Miss Bradley, who also appears in court. My lords, this is the local authority's appeal against a decision of His Honour Judge Thomas, dated the 16th of September 2025. My lords, I'm conscious that this matter is being live streamed, and in those premises I certainly simply intend to refer to the subject child as the child. I don't intend any discourtesy to the parents who I know sit at the back of court, but I'm sure they will understand the reasons for that.
Indeed.
My lord, the court will note that this application was issued promptly on the 22nd of September 2025, but unfortunately there was a significant delay in obtaining the transcripts from the original hearing before His Honour Judge Thomas, which led to permission to appeal only thereafter being granted on the 13th of November. The court has before it today, I hope, three bundles of documents filed on behalf of the appellant. Those comprise a core bundle, a supplementary bundle, and a bundle of authorities. That bundle of authorities was added to yesterday with three further documents for which I'm going to invite the court to provide leave in due course to rely on. There is additionally a further bundle of documents accompanied by an application on behalf of the respondent father, and that bundle of documents includes the father's skeleton argument. There are two preliminary issues. The first relates to additional material filed within the father's bundle of documents, and that amounts to placement logs for which an application is made pursuant to the relevant rules to admit that evidence. I should say on behalf of the local authority that application is not opposed, but submissions will be made in due course as to the probity of that information if the court permits the father's team to rely upon the same.
Well, if it's not opposed by anybody, then it will come in. I mean, I appreciate that there is at least theoretically the possibility of opposition from elsewhere, but I would have thought primarily it's the question of whether you oppose it and you tell us you don't. So therefore, we will be looking at it for what it is worth. And obviously, we'll see how the argument goes, but it may be particularly germane if we get to the stage of setting aside the judge's decision and reconsidering the matter.
My lord, yes, I'm grateful. The further matter, as a preliminary matter, which I would wish to address, relates to the additional authorities which I filed, or the local authority filed yesterday. Those, I hope, have made their way into your lordship's bundles, whether electronically or otherwise. Various permutations were sent to the court in the hope that that would make the court's job slightly easier to navigate. Those authorities follow on from the original authorities bundle, and a revised index was prepared in accordance with the same.
Does that mean there's now a bundle containing 7 authorities from the appellant?
Yes, my lord, yes.
Thank you.
Yes, and hard copies of those additional authorities were handed up this morning to be added to the ends of your lordship's bundles if your lordships are working with paper bundles.
Thank you.
Turning to one matter that I know concerned the court at the time that permission was granted, and that is the length of time in which it took for the transcripts of this matter to be produced. I have made inquiries, and I simply wish to assist the court with that. I've made inquiries with those instructing me. An application for those transcripts was made in the proper form on the 23rd of September. There was then a lengthy set of exchanges as between the court office and my instructing solicitor on an almost daily basis at points whilst that transcript was sought. The court eventually, on the 7th of December, 7th of October, I apologise, informed my instructing solicitor that the transcript had been sent to the transcribers. Those instructing me had requested an expedited transcript. For reasons which are unclear, it still took 10 days to return to those instructing me in the form of the hearing transcript that your lordships have. The judgment transcript then had to go to His Honour Judge Thomas for perfection, and that process took a further 3 weeks, by which time the court was provided with that on the same day it came to the local authority. The correspondence between my instructing solicitor and the court office continued throughout that period whilst that judgment was in the process of perfection. I cannot say, and I don't have the information, certainly my instructing solicitors don't, know what date the transcript of the judgment was sent to the judge below for approval. So I do not know where the delay in those 3 weeks arises, but it was a 3-week period between receipt of the first tranche of the transcript, if I may say, and the final.
Thank you for that explanation.
Can I assist the court any further with that aspect of?
No.
I'm grateful. My lords, turning to the substance of the appeal then. The local authority filed, along with the appellant's notice and grounds of appeal, a skeleton argument prepared by my predecessor, albeit the court will note that the attendance at the hearing was again different. So I, like my predecessor, do come to this matter fresh, and were of course reliant on the contents of the transcript as it came to us. The thrust of the case advanced on behalf of the appellant is that the learned judge below simply did not give sufficient consideration to the wealth of evidence which the local authority says was available to the judge at that time. The learned judge, in his own judgment and during the course of exchanges with the representatives at the hearing, makes absolutely plain that he has not had time to read into the matter beyond consideration of the final report of the placement in which the parent and child were and remain living. He was taken to a further document during the course of that hearing, which amounted to an appendices or an appendix to the final report that was relied upon by the local authority. But that, in my submission, is effectively the extent of the reading which His Honour had been able to do. It was, as the court will appreciate from consideration of the transcript of the hearing, in many respects a brief hearing, starting at 11:43 and finishing at 12:14, so about 31 minutes. And I take my starting point for my submissions, with your lordship's leave, as the transcript of that hearing, which is found at Core Bundle 53. And in the course of that, the exchanges, a primary observation, I will say, from an overview of that transcript, is that there was very little by way of submissions permitted, I say, on behalf of the local authority. The learned judge at the outset, on page core bundle 54, sets the tone for the hearing by noting at where we see it at paragraph D on that page, that the question of whether or not the parents are leaving the placement or intending to leave the placement is a crucial one, and he therefore turns to the parents' representatives to seek clarification of that. Having sought clarification, he then over the page states, without hearing any further significant submissions on behalf of the local authority at all, states quite simply and plainly, you can't bring yourself within Re C, can you?
And that comment follows, in fact, from the proposition that if the placement hasn't given notice, then you can't bring yourself in.
Yes, my lord. Yes, entirely. And I say that that is what sets the tone for the hearing that is to follow, however brief that hearing was. And it's correct, and I certainly don't suggest that His Honour has misidentified one of the pieces of the relevant case law which must be applied. But by using Re C as a shorthand, he has fallen into error from the very beginning in my submission. And it was from that starting point, when one considers the transcript, it was from that starting point that the hearing continued. And to almost every submission made by the local authority, His Honour refers to that particular test and that particular piece of case law. And when we look further down this page that we are on now, CB 55, His Honour questions the local authority. Well, do they, forgive me, do they say in that report that this child in that setting, supervised, is at risk of physical or emotional harm? Because I haven't read it, in which case it's a flawed application, it seems to me. In my submission,
I haven't read it is ambiguous. I haven't read that comment in that report, rather than I haven't read the report. But I take it it's the former, not the latter, because I think there is every other indication that he actually had read that report.
Yes, my lord, that is how I had read that comment,
yeah.
that he has, his Honour has read the report,
Yeah.
but he hasn't seen
Read
that specific
that
comment
Yes.
in it. But it is the categorisation, I say, at that stage, when the local authority has, in my submission, barely opened the case, the categorisation of that, the application as being a flawed application, which leads His Honour into error, because it is the starting point, it's the framework by which he approaches the balance of the hearing. I'm not going to slavishly go through this transcript. I know that your lordships have a copy, but I say that it stands in stark difference. His Honour's commentary stands in stark difference when considered against the discourse between His Honour and the representatives for the parents at that hearing. When seeking confirmation, or when addressing the parents' representatives, which falls only 2 pages later, 4 pages later, apologies, on CB 61, His Honour says, I'm not convinced it meets the test, Mr. Batt. Do you need to say anything? That is having heard lengthy submissions over the course of the previous 2 pages on behalf of the child. Miss McGrath, who was representing the local authority at that hearing, as in this court, is enabled to make lengthier, I should say, submissions as to the fundamental aspects of the application which are before the court. But those submissions do not receive any judicial attention during the course of submissions. There is no, beyond an interruption which I will refer to in a moment, there is no engagement with the contents or the thrust of those submissions made by counsel on behalf of the child, who of course adopts an entirely separate approach, an entirely different role to that of the local authority. And whilst I accept, on behalf of the local authority, there were limited opportunities, I say, for the representative for the local authority to actually deal with the thrust of the case in the time that was permitted, Miss McGrath is rather more successful in addressing His Honour on what the concerns are which led to the application being made. And again, I am certainly not going to dwell on the contents of Miss McGrath's submissions and trespass on her submissions for today's purposes. But I say the key element, the matter upon which the court was duty-bound to engage on an application of this nature, is encapsulated at CB 58, paragraph G.
The level of care she's receiving.
Yes.
That paragraph.
Because it is that in my submission, my lords, which takes directly from the final placement report, which is in the core bundle, and starts at CB 98, and I look at CB 101. The two concerning areas of the parenting assessment which have been undertaken. And those are helpfully tabulated as amber areas and red areas. The Guardian submissions within that hearing focus very significantly on the contents of those sections, the issues and the concerns which they raise, and the reasons why they go to the heart of the application that is before the court. However, the Guardian then goes, or Ms McGrath then goes further than that, and what she invites the court is also to consider the full spectrum of the information that is available to the court, which starts with, for the purposes of this application in reality, with the Midway Parenting Report, which was prepared on the 27th of June, which then feeds into the final parenting report to which I have just referred. And the reality is, my lords, that those documents are interrelated. Those documents are inextricably linked because they demonstrate, in my submission, the development, or indeed lack thereof, in the time period with which His Honour was concerned, in the ability of the parents to provide safe and appropriate care. That in itself, in my submission, is then supplemented by the document that His Honour was taken to by the local authority, which is the summarised chronology prepared by the placement. And for your Lordship's reference, that starts at Supplementary Bundle 69. that eight-page document encompasses the interventions and the work, to put it in its most broad form, that has been undertaken during those two periods. So His Honour, in my submission, was on notice that there was a relevance to that document and that he should consider those wider aspects. Now, I'm aware that, certainly on behalf of both parents, it's said, and it was said at the time, and indeed His Honour at the hearing, indicated that he considered those to be final hearing issues and longer term issues. I, of course, accept that there is an element of that. There is an element only. But what the court has before it is a detailed analysis of what is happening on the ground and on a day-to-day basis for this child. And the local authorities case simply was that was placing the child at risk of harm. And I say, one can. Apologies, I would invite the court to consider within the Re-L case that was cited in the authorities bundle my apologies, my lords. It's authorities bundle 29. The case itself starts somewhat earlier than that. At page 20 of the authorities bundle. But at authorities bundle 29, paragraph 37, simply refer the court to the submissions made which did not receive judicial approbation in the Re-L case by her ladyship during the course of her judgment. And it's absolutely right that on occasions, courts will take decisions at an interim base, on an interim basis, which do look at the longer term aspects. That is unfortunately the reality of where these applications are made. And I would say that this application, in fact, stands apart from many applications of this nature, which, as my learned friend on behalf of the father refers to in her skeleton argument, as and I summarise, being effectively the diet of a family court circuit judge, i.e. applications for interim separation, interim care orders, and the like. Those applications I accept necessarily at the outset of proceedings come along at a time when the evidence is incomplete. The evidential picture is far more unclear than it is in this case. And in this case, what the court has before it is not one but two significant reports from an expert instructed with the permission of the court.
I mean, as I see it, your case is that the judge should undoubtedly have read the 2019 Re-C, paragraph 2,
yes.
Lord Justice Peter Jackson's summary of principles, in light of what Lord Justice Peter Jackson went on to say in the second Re-C, 3 months later, at paragraphs 12 and 13, namely, a decision of this kind calls for the evaluation and balancing up of the factors relevant to the child's welfare.
My lord, yes.
Which provides a wider purview than the simple, as it were, agonal event that one might otherwise be looking for in
My lord,
2019 yes. Re-C. And then at paragraph 13, one's looking, isn't one, for indications that the judge has, to use the phrase of Lord Justice Peter Jackson at paragraph 13, the bottom line, assessed the evidence coherently
My Lord, yes.
in order to reach a decision at an interim stage. And as I understand it, when you take the 2019 and the 2020 resees together, you say that this judgment is lacking in a coherent assessment of the evidence taken as a whole, and a failure on the part of the judge to evaluate and balance up the range of factors which were in play in relation to the care of this baby.
My Lord, yes. The fundamental part of the local authority case, if I can put it that way, is that the learned judge below adopted too narrow a view of the test which Lord Justice Peter Jackson set out in that first resee, but didn't factor in what, or didn't in fact take a wider welfare evaluation, which he is required to do, of course, by Section 1 of the Children Act.
You say he appears to have treated the 2019 resee as the be-all and end-all of the test, and that was that.
Yes.
But undoubtedly, the decision that he was being required to reach on the 16th of September was a question with regard to the upbringing of a child, which statutorily engages Section 1 and Section 1.3.
My Lord, yes.
Can I just ask you about your submissions a moment ago about the relevance of the evidence for the final hearing?
My Lord, yes.
You made the point that there was, in this case, a lot of evidence available which would be adduced on the final hearing. Is it your submission that the judge should have taken into account that evidence as to what was to happen finally in making his interim decision, or do you not go that far?
I don't go that far, my Lord, but what I do say is that the learned judge was duty-bound to take into account the evidence which was relevant to the welfare determination that he had to undertake, rather than doing so through the narrow prism of a convenient but nonetheless, in my submission, erroneous shorthand.
It would be helpful to me, at least, if you can identify, Mr. Frown, what other matters, specific matters, you think the judge should have taken into account in the, as again Lord Justice Peter Jackson calls it, the anxious decision-making that is engaged in this kind of case, when he undertakes the balance.
My Lord, yes. I can refer simply, Your Lordship, to those matters that are set out at CB 101 onwards, but in particular, the areas which are described as red areas, which are the fundamental concerns about the manner in which these parents are approaching the parenting task, and what leads the author of that report to ultimately conclude that they cannot do so. For example, my Lord, and I will turn to those matters that are raised by my learned friend within the updating material, because a lot of them mirror, in fact. But the reality is, we have simply put issues regarding feeding of the child, issues regarding routines, managing a diet, taking professional advice, the parent's own relationship and codependence, the parent's ability and or, in the case of the mother, willingness to either accept professional advice or work with professionals, the parent's ability to regulate in times of stress or otherwise.
So when we cross-refer in the judgment to paragraph 4, the judge there says, but there are concerns, and these concerns, as far as the mother and father are concerned, are set out in paragraph 12.
Yes, Madam.
Paragraph 12 is paragraph 12 of the final report. Am I right?
Yes.
And I think
Yes,
we can
that's the only
confirm
document.
that because he says that the assessment has highlighted areas of concern, but with support, the mother and father are likely to continue improving their parenting skills. Yes?
Yes. But he doesn't refer to then thereafter the more fundamental concerns and the more fundamental aspects of the parenting task, which are noted in red.
Yep.
So he only refers effectively to those in amber, but does not go on to deal with the aspects which I've highlighted.
Thank you.
And that is the extent, in my submission, of his consideration of those factors and that wider exercise that his lordship in the latter REC refers to. This is, and I don't criticise His Honour in circumstances where I don't doubt he was in the middle of a very busy list, but this is an incredibly brief judgment, I say, in which he utilises that shorthand which I've already referred to as a shortcut to effectively saying there is no precipitating event, there is no marker in the sand which I can lay my finger on to say that the REC 2019 test is satisfied, and therefore the local authority's application is doomed to fail.
Can you just assist me with a point of information? The report from the placement is said to be a final report.
Yes.
The couple with the baby had been there all together for three and a half months, something like that. And of course, we know that the final hearing isn't listed until April of next year. Was it expected that the placement would in fact end sooner than before the final hearing? It occurs to me that it's strange in a situation like this that you get a final report from a placement with still many, many months to go before a final hearing.
Well, my lord, that is a factor, and it's one that I wish to address in response to my learned friend's grounds of appeal or the documents relied upon. The placement was initially instructed, as I understand it, for pursuant to an order by His Honour Judge Scarrett. His Honour Judge Scarrett declined the invitation for interim separation on behalf of the local authority.
Yes.
There were then a sequence of hearings, as the court may have seen, and the placement was ultimately endorsed on the 23rd of April.
Yes.
With a provision, as I understand it, and I have not seen a letter of instruction, but my understanding is the letter of instruction sets out a 12-week assessment period.
Right.
With a midway report
I see.
in the middle. That is the...
Well, one sees that from paragraph 2 of the report.
Of the report.
Page 99, where the author says he had instructions on the 19th of May to provide a midway report by 17th June, final report 12th August.
Yes, my lord. I'm most grateful. I had omitted that reference. So that is the basis upon which the unit was instructed to undertake its task. The local authority's application thereafter followed, following receipt of that report.
Yes.
The final hearing was not listed, as the court will have noted, until the time of that case management hearing, and there was some dialogue between the advocates and the judge as to whether or not to list a final hearing, and ultimately His Honour was persuaded to do so.
Yes.
But that then left a significant gap of about 6 months in which the child was to be left in that placement. And it is, as my learned friend on behalf of the child said during the course of submissions, that the reality is, in the event there was a 2 or 3 week or even 4 or 5 week wait for a final hearing, then that is a balance which could be held effectively. But when one is looking over the course of a 6-month period, that is when things become more problematic. CB 59 is the reference for that, my lords, paragraphs F and G. And if I can deal with this aspect now, it relates to the logs which the court has before it in a lengthy bundle provided on behalf of the father. Those logs in my submission, whilst I have to accept, and I do accept readily, that they do demonstrate some positives in the parenting that is being provided. They additionally continue to raise significant concerns regarding that parenting. Those concerns include continued worries by the staff about the routine not being established for the child, continued observations of the parents being distracted whilst caring for the child, continued supervision, close supervision, whilst the parents are conducting basic care tasks. Now, the court will note that, for example, at Father's Bundle, page 269, the 4th, 5th and 6th and 8th of October, some 5 and a bit months after the parents have entered the residential placement, the placement staff are still having to wake them up at night in order to provide feeds for the child. Similarly, further on, continued worries about the parents' relationship, for your Lordship's reference, Father's Bundle, F291. And again, a reference.
So we're on 291.
Oh, I'm so sorry, Your Lordship. The bold text is 12:10:25, and it's the time 11:15.
Thank you.
And then again at 17:02. A few pages on at 3:08, my lords, the 19th of October 2025 at 1:20, record of the mother asking about the food.
Sorry, which page?
Oh, apologies. The 3:08 of the Father's Bundle.
That's 308.
And then again, my lords, simply to highlight the point at 332 of that bundle, concerns regarding bathing, supervision regarding bathing, and indeed lack of routine. It's recorded that the parents are still working on establishing a routine. My lords, that is a work that has been underway for almost 5 months by the time of those logs being produced. The relevance, I say, of all of those matters, however, and the reason I bring those further authorities before the court at this stage, is that the updating logs bring into sharp focus the tension between the aspects of interim care orders and interim separation, which your lordships are primarily concerned with, and the proper application of Section 38(6) of the Children Act. Because what I say those logs demonstrate is that for the period in which they are relevant or cover, those logs demonstrate that what is being provided is not assessment. It is not assessment of the child. It is at best classed as observational monitoring and teaching. And the reason I say that is relevant arises within the 3 cases which I have filed within the last 24 hours, re C, a decision of the House of Lords, re G, a decision of the House of Lords, and re Y, a decision of this court by Lord Justices Peter Jackson and Moylan. My Lord, paragraph 65 or additional page 85 of the authorities bundle in re G. My Lords will see at paragraph H in the speech given by Baroness Hale, as she then was. Her Ladyship is clear that the purpose of section 38(6) cannot be to ensure the provision of services for the child or his family. And what the court has before it in the form of the evidence that is now relied upon and admitted by your lordships is exactly that. It is services being provided which are not for the purposes or for assessment. I can refer simply to that factor. The headlines of the logs have changed. I apologise, I did find a front page of those logs. And where it says on effectively the front page of the logs which are now produced, for example, at...
Well, if you see 329, is that what you're...
Where
it says assessment completed.
Assessment completed.
That's the point.
Indeed, that is the phrase, that if there was ever any clearer indication of what is now taking place at this unit, is not assessment. It is monitoring, and it is teaching.
Well, can you just help me to understand what the legal relevance of that is? I mean, I understand your point that assessment is being completed, but in circumstances where the court is undertaking a welfare evaluation of the child, is the court supposed to shut its eyes to the fact that currently support, to use a different term, is being provided?
My Lord, the issue is, and I'm grateful for your Lordship framing it in that way, because the issue as I say it stands, is that when the matter has the conclusion of the assessment, or the assessment has concluded, the power of the court to require the local authority to maintain that placement in the form it is, has fallen away. Because it is not, in my submission, open to the court to require the local authority to maintain a placement in a residential assessment centre. But that is what this is.
That isn't how the case was put.
No, I accept that entirely, my Lord, and it arises as a result of what we now know about what is happening on the ground, rather than any criticism of His Honour at first instance.
So that feeds into the question whether they will remain in the facility.
Yes.
Pending the final hearing.
My Lord, yes.
Well, and you're right to draw that to our attention, but what is the local authority's position in that regard?
Well, my Lord, it is a matter which I say is relevant when the decision falls to be considered, as I say it should, on a further occasion. It is a relevant matter, and I bring it to your Lordship's attention because it seems to me a tension between the two areas with which the court is concerned. Firstly, within the interim care order separation question, but then it feeds into, now that we know what is happening on the ground.
To be sure, and as I say, I think you're right to bring this to our attention, but nevertheless, one's bound to ask, well, is it the local authority's position that the position is going to change between now and April. Of course, when we get to April, the court will be considered with a final order, and it's not our task, and it would be quite wrong for us to try and prejudge what happens at that stage. But we are concerned here with the interim stage. And so are you able to say anything about what the local authority's position is as to what should happen between now and April? And I return to the observation I made earlier. This will become particularly pertinent if we get into the scenario where we set the judge's decision aside and contemplate whether to retake it ourselves.
My lord, the local authority's primary position remains, notwithstanding what are said to be positives in the observations. When one looks at all of the matters that are contained within even those logs that I've referred to, the local authority continues to pursue interim separation.
To be sure, I understand that. But you were making the point that this placement had been provided for the purposes of assessment, and assessment was now complete, and therefore, inferentially, continuance of the placement could not be guaranteed. And I understand why you say that.
Well, at this stage, of course, the local authority did not have permission to bring that placement to an end by virtue of the nature of the order that was made by His Honour at the time. The local authority's clear view is that separation is required. I'm not sure that I can go much further than that at this stage, because it seems to me that those questions are inextricably linked and will need to be considered by the learned judge if this matter is to be remitted for rehearing, because the assessment portion has completed. So arguably the direction made by His Honour in April for the assessment to take place, that has been complied with. And it is therefore whether the court on below, if the matter is remitted, may take a view on additional assessment, for example. That may be a matter that the court below is tasked with addressing.
All right, well that, I think, raises conveniently the related question, which is this. Suppose we conclude that the judge's decision is flawed, and therefore should be set aside. Is it your submission that this court should remit the matter, or would you accept that we were in a position to retake the decision ourselves?
My lord, I would say respectfully that this matter should be remitted to a different judge. It is not in any way a discourtesy to your lordships, who have of course got a great volume of material before your lordships. However, the information which is now available in my submission requires full argument in relation to the updating logs. It may be, in light of the contents of those, that the court would need to hear some brief oral evidence from the placement itself about matters on the ground, and that is a step which should be taken in a remitted hearing. I do not say that the court is required to conduct effectively a mini-final hearing, but a remitted hearing may involve some element of evidence giving as to the manner in which the various tests, the welfare test, the re-see test, when drawn together, apply to these particular circumstances.
Well, I'm grateful for that clarification, but it leads on to this further question, which takes us back to the submission that started these questions that you made, which is this. I mean, as my Lord Justice Cobb pointed out, we're in a scenario in this case where there's a considerable
gap
in time between the final report and the final hearing. Now, one might have thought that if we set aside the judge's decision, and I emphasise if, and if we remit the matter, as you suggest would be the appropriate course, then the court on the remitted hearing would at least be assisted by updated expert evidence. I mean, particularly if logs are being put in evidence, behavioural logs, post-dating the final assessment, that puts the author of that assessment into a somewhat difficult position, because on the one hand, he's given his opinion as at 12th of August, based on all the materials he's considered by that point in time. And the court is then being asked to take into account subsequent material, which he's had no opportunity to consider.
Well, Lord, yes, and that is the reason I say that there may be some brief or some oral evidence from the author of that report, who is a member of staff within the unit. It's an internal report that's prepared. He would have an opportunity to consider those logs. He would have an opportunity to provide any views during the course of such a hearing. It does not, as I say, require a further formal assessment period, but the author can be invited to comment on what the information says about the intervening period and whether or not that alters their view.
Yeah. I suppose it might be helpful for that person to be able to categorise the new material in the way that the earlier material was categorised, by reference to a sort of traffic light type
Yes.
Process, so that at least on any remitted hearing, a judge would be able to see what would have been classified as red, amber or green.
My Lord, yes. And the question, the red, amber, green is a feature of the particular variety of parenting assessment that was undertaken in these proceedings, but it is a helpful marker, not only for the professionals and the court, but indeed the parents. And it is for that reason that it was developed. Returning, if I may, my lords, to the point that brought about that exchange with your lordship, the fundamental issue that I bring to the court on that aspect is that interplay, as I say, between the REC line of authorities and Section 38(6). And what I say is the inability by the court, in circumstances where the Children Act has very clearly demarcated the roles of the court and the local authority, to require the local authority to continue to fund at significant expense the costs of a placement which is not doing what Section 38(6) requires of it.
Yeah.
And that is, I may say, not only a relevance to this case, but has broader relevance. Because of, my lord, there will be many cases in which there is a delay between the receipt of a report and a final hearing. That is the nature, very unfortunately, of listings currently in the family court. And the question in my submission that must be asked is, where does the authority of the court lie in requiring those circumstances to continue without a basis to do so? And Her Ladyship, Baroness Hale, is very clear in my submission during the course of Re-G as to the respective roles of the court and the local authority and the discharge of those roles. Re-G, as the court may be aware, if the court's had an opportunity to consider it, ultimately concluded by agreement, or the circumstances on the ground effectively overtook the nature of the appeal, but it was an appeal that continued in principle.
So can I understand, Mr. Farage,
Sorry.
whether you finished that particular point, but can I then understand that if the case were remitted, your primary case would be, am I understanding this correctly, that the current evidence demonstrates that the REC 2019 test is satisfied, and that there is a proper justification for separating child and parent at this stage. But that you, am I right in understanding this? You would have a secondary argument, which is Section 38.6 assessment is now complete, and then place the which denies or deprives the court of authority to continue or to authorise or order the current placement at
My Lord, yes.
Yeah.
That's the essential two-part element that would be put before the court if the matter was remitted.
Thank you.
So what was taken for granted, it appears, before the judge, that parents and the child would remain in the placement, cannot be taken for granted on remission, is your point?
My Lord, I say that on a proper interpretation of Section 38.6, that cannot be right. And it will be a matter, of course, of very fact-specific circumstances, and the learned judge on any remitted hearing will need to grapple with that particular issue and the extent of assessment, etc. But as it stands now, from the evidence that we have before us, it is an issue which must be determined.
Is that a point that you could bring before the court anyway on a further application? Assuming that there had been no appeal, could you have come back to the court on some further occasion and said, we want a decision from the court on our responsibilities, whether we're required to continue providing this facility, and if we're not, the circumstances fundamentally change, so there should be no further interim relief?
My Lord, there is both a legal answer to that question and indeed an anecdotal answer to that question. The legal answer is yes, that application could properly be made, albeit I respectfully refer your Lordship to the judgment of His Honour Judge Thomas, or the transcript of the hearing, in fact, in which it's very clear from the outset that His Honour Judge Thomas is looking through the prism of a shorthand which I say is impermissible. However, I may speak, if I may speak anecdotally, such applications, if made, are generally given the same level of shrift, if I may say, that this one was, on the basis that the child is somewhere and separation is therefore invalidated. And that is the reality on the ground, because effectively those two areas cross over, and the REC shorthand is used to effectively say, well, the child is safe, therefore they must stay.
Indeed so, but this is the importance of the point you raise, because you say this should not be predicated upon the provision of support by the local authority, which the court has no power to order to continue to be provided.
My Lord, indeed, and that is the issue, but it is one that, as I say, invariably receives little judicial attention. The focus of judicial attention being the ill, if I might describe it as that, of separation.
All right.
To put that into context, my lords, the current placement with which your lordships are concerned costs over £6,000 per week.
Is your submission that if it were remitted to another judge to remake the decision, including hearing your submissions on that point, those submissions would receive short shrift then?
I can't speak to.
Well, you
I
can't
can't
speak for it, but
I can't speak for the learned judge below.
No.
I can speak to my own experience. That it is ultimately the responsibility of the local authority to implement the care plan which the court has said must be implemented, i.e. Not to separate the child, and therefore it is the responsibility of the local authority to pay for it.
But I'm just wondering, which aspect of the judge's order are you there referring to?
So, my lord, I'm not, in respect of that submission, or those submissions, not referring to this learned judge's determination. That was simply in response to your lordship's questions, and setting out the anecdotal position as compared to what should be the legal position on such applications.
Yeah.
The mischief, I say, is that the learned judge at the outset set, as I've said at the beginning of my submission, set the tone for that application and did so without any reference to any other factor. Now I accept entirely, as I must, that it was not framed in that way on the part of the local authority, and I must accept that. But it was said by my learned friend Miss McGrath in terms at CD 59, paragraph B. Now, the manner in which my learned friend on behalf of the child frames the question is perhaps not quite how I've put it at this stage, but the fundamental question about the ongoing nature of assessment and the conclusion of the assessment is what in my submission my learned friend is referring to here. And His Honour, in one simple sentence, says, that's not my concern. With respect to the learned judge below, it should be a concern. And the reason for me addressing the court on those, in that anecdotal way that I have, is to highlight that that is not, in my submission, an unusual response.
Well, yes, but
I appreciate
your principal point is a legal one,
yes,
which is the statute as interpreted by the House of Lords is perfectly clear, you say.
my lord, yes.
And I suppose, in fairness to the judge on this point, you weren't raising, or your colleague wasn't raising the Section 38(6) point.
No, my lord. My colleague did not raise that, or my predecessor did not raise that, and I accept that entirely. But the learned judge was on notice of that as an issue following the submissions of my learned friend on behalf of the child. I would say that the learned judge, in fact, gave the then representative for the local authority very limited opportunity to make submissions. The submissions that were permitted on behalf of the child were significantly longer.
Yeah, well, we understand the point you make, so we see it very clearly at page 58, where at A, the judge says they don't say the report at risk, that's a fact. As Ms. Bass has given the chance to say no, and then it's straight on to the Guardian.
My lord, yes.
And when the judge says, can I speak to the Guardian, what he means is, can I hear from the Guardian?
My lord, yes.
Yeah.
My lord, I'm not going to labour the points that are made in writing, or indeed to go through in granular detail the contents of the various reports which the court has before it, unless the court wishes me to do so. I have summarised at this juncture the manner in which the local authority puts this case. The primary focus, as your lordship has identified, is that the learned judge was wrong when one takes together the two re-Cs in his approach. That is the fundamental submission I make.
Yeah.
The secondary position, that relating to section 38(6), is a an argument that I advance on the basis of what we now know, but I certainly accept and recognise that His Honour was not addressed in terms by the local authority on it, but it was nonetheless in my submission something which he could and should have been on notice of in the proper application of the relevant parts of the Children Act. For those reasons, I say that the matter should succeed, the appeal should succeed, and that the matter should be remitted for further hearing by a different tribunal. My Lords, are there any matters at this juncture which I have not dealt with during the course of my submissions with which I can assist your Lordships?
Just one point from me. Do we have the order of District Judge Whitfield in the papers anywhere?
My Lords, it is not in the papers, but I will obtain a copy and send it to your Lordship's clerk during the course of submissions.
Thank you.
I'm grateful.
Thank you very much.
May I just turn my back for one moment, please, my Lord? Unless I can be of any further assistance, my Lord.
Thank you.
I'm grateful.
Yes.
My Lordships. Excuse me. On behalf of the mother, at this stage, my Lords, I did a fairly lengthy skeleton argument on the basis that I'd been at the hearing, and apart from Mr McGrath, we were the only two, I think, at that hearing, and summarised matters as best I could at that time on the basis that, as you have heard and appreciate, the hearing didn't last very long. 40 minutes was my note of it, and the way in which the Honourable Judge Thomas dealt with it has been described now in some detail, and I don't need me to repeat everything. He effectively asked Miss Barter for the local authority to summarise the concerns and then went straight to Miss McGrath, having indicated to me and indeed counsel for father, who was represented by the OS, it didn't necessarily need to hear from us. That always places an advocate in some difficulty in my respectful submission, because it was an application to separate, and one expects to deal with it on the merits of the application. In my skeleton, my Lords, I've set out in effect what took place, the interchange that took place, which is now in the transcript, and the judgment of the hearing I didn't have at that time, and tried to summarise the positives from the interim midway report, because the central argument that was being put forward was not necessarily that the child was at immediate risk of physical harm, although there were issues concerning diet and feeding, but that the prime concern was if the child was permitted to stay in this placement, there would be harm, and that the judge had not taken proper consideration of the likely emotional harm that might be caused to the child. And in my skeleton, I've referred to it's in the benefit of paragraph 22 of my skeleton, the final review under stimulation, that sets out the paragraphs 23 onwards, that the parents continue to demonstrate strong skills in promoting age-appropriate stimulation to the child and so on, and are able to provide stimulation which is well documented in the logs. So to that extent, the main point that was being stressed by Judge Thomas and also by me was that there was no, well, when I was able to, there was no actual evidence, which is what His Honour Judge Thomas kept referring back to, of any actual harm to this child. And the thrust of the dialogue between the judge and Miss Barter was to that effect, and Miss Barter conceded that they were not saying there was immediate risk. And indeed, when the guardian, Miss McGrath, was able to address the court at further length on behalf of the guardian, His Honour Judge Tom had interrupted on to point out that as far as he was aware, there was no direct evidence, and that both the local authority and the Guardian, as he put it, fall into the trap of dealing with addressing matters that were fundamentally for the final hearing, and that it was not his role to determine those issues. And it is right that he kept referring back to the test in Re C 2019, although that wasn't specifically referred to. It's referred to simply as Re C. And I've summarised that in my skeleton argument again. But the difficulty, as Mr. Fowler said, that we go to court these days and refer to the test as it's referred to in Re C, as if we all still know exactly what it is like. It's embedded in our mindset. But it's the important points that I draw out at that hearing and try to, and indeed in my skeleton, is that the evidence that was put before the court relied upon the local authority and to deal with the interim separation was in fact putting the parent at a disadvantage, were final hearing issues, and that simply it wasn't necessary or proportionate, as indeed the test says, to actually order separation at that time. Because the difficulty, as I saw it on at that hearing in September, was that the interim report was in June, I think, which had concerns, but nevertheless recommended further assessment. The August one simply highlighted, because of the nature of the assessment, that there were ongoing concerns sufficient that it didn't actually say that they couldn't care for the child because they weren't being asked to, but the negatives were drawn together. The local authority took the view it was a negative assessment, and hence the application to end the placement and to separate. But His Honour Judge Thomas was at pains to point out that nowhere in that assessment had it said there was a risk, or that indeed that the placement, I think I've referred to the fact that it said placement, the assessment should come to an end, or the placement should come to an end. I think it was the assessment. But again, His Honour Judge Thomas asked specifically on more than one occasion, has the unit or the placement given notice? And of course they hadn't.
But is it a matter purely for the decision of the unit? Isn't it a matter primarily for the local authority?
Well, generally speaking, my lords, again, in experience, is that the units say that they've carried out the assessment is negative, and they wish to bring the placement to an end because they can't provide or keep the child safe, or can't provide the level of monitoring that's necessary. In some cases where it could be 24/7, one-to-one assessment, they simply say we cannot maintain this position. It's not safe.
No, I mean, and you're right to point out that scenario had not arisen. So you're right to make that point. But the question I was asking more related to the question that was raised by Mr. Brown, which is, even though the unit hasn't, as it were, raised that level of concern, such that they were minded to withdraw support, the question that has to be asked is, on what basis can one assume ongoing support by the placement in circumstances where assessment is at an end and the court has no power, so Mr. Frowell says, to order continuance of the support?
The reality, again, I think, my lords, is that the unit has provided it, and it's been ongoing, and the effect of the additional information that Michelle, on behalf of the father, was going to rely upon, which is not contested, is that the parents are continuing to make reasonably good progress, but they say very good progress, to the point where it's been indicated to them that there may need to be an updating assessment. There's been no, the answer to the point is that the report was in August, the hearing was in September, we're now in November. There have been no major concerns raised sufficient for the local authority to bring this matter back to court on an emergency basis to say this child is at immediate risk of harm. Because in a case, I think, the case that's referred to, I think, where the mother was in prison, and that was an issue there. One of the arguments that its Honour Judge Thomas made is that asked the local authority and the guardian, is this child going to be at risk or unsafe when it's in a unit, when it's being supervised and monitored?
Well, exactly, and that's the point I'm trying to probe, because I fully take your point that there's been no alarm bells, as it were, that have caused the unit to give notice or to cause the local authority to make a further application at first instance. I understand the importance that you place on those points, but my question was directed to a slightly different question, which is you just touched on, because if we look at it might be helpful to frame it by reference to what the judge said in his judgment, which you are defending. And it's core bundle pages 51 to 52, paragraph 7, where he refers to the red areas in the report, and then he quotes the author saying ongoing staff supervision within a structured and protected environment remains necessary to ensure the child's welfare and support. And then the judge says this: it seems to me this is the flaw in the application, because the parents are remaining in this structured and protected environment. And the point that's made by Mr. Froud is, well, how could the judge make that assumption? Because he's assuming, to put it bluntly, that the local authority will continue to fund that, and they're under no obligation to do so. They have other children to think about.
Well, I can't speak for the judge, but what I can say is this, my lords, having been at the hearing, that point was raised on the basis of the cost and the fact that other families were being deprived the opportunity to remain at this placement. And Judge Thomas, my recollection is he said, well, that wasn't his concern either, because it's not part of the test.
But do you say he's right as a matter of law to say it's not his concern?
That again comes back to the conflict between Section 38(6) and Re C. As a matter of law, I'm not aware that there's any direct authority on the points, my lord. That is the difficulty. He made that decision in the short time he took of the hearing to say that all the time this child is remaining in the placement and is safe, he was not going to be satisfied that the test in Re C was met. So it becomes circular, because he assumed that by not ordering separation, the child was going to remain where it was.
But there is no paragraph in his order which orders the local authority to do that. There isn't even any paragraph in his order with regard to the interim care plan.
My lord, I can't argue against that. The fact is that there is the case that is not before you on at the moment, a case of Re F and T in 2015, which I have the citation, which Miss Ellis and I were discussing it overnight. I beg pardon. It's just trying to look for the citation is not beg pardon, my lord. It's 2015, EWCA Civ 880 decision before Lord Justice Richards and Lord Justice McFarlane, and effectively that was a discussion, a case that there was the issue about whether or not there should be an interim order, interim separation, or a residential or a placement, and the court took the view in a nutshell in that case that if it was decided that it was necessary effectively for there to be a residential assessment, requiring in effect an ICO, an interim care order, to allow that, then that was an end to the matter. But if that was not the case, then we went the issue reverted back to the issue of separation and whether that test, on the basis the tests are different in the two situations. So if Section 36(a)(6) was necessary, then you didn't need to consider interim separation or removal. If it wasn't, then you had to go back to consider that. But in this case, of course, the children, the point is already made. The parents and the child were in the placement. So to that extent, it's relevant to that issue. But
except that the assessment is completed.
Yes.
Except the assessment, unlike F&T, the assessment is completed.
That is the difficult one, yes.
Yeah.
So what is your submission on that?
Well, my submission, on the basis that several, in this way, my lords, on the evidence that was before the court on the 16th of September, my first submission is that the judge was entitled to take the view that the test in Re-C 2019 was not necessarily met because there was no actual evidence that was put before the court of any actual harm to this child. There were, it's repeatedly referred to, significant concerns about the parenting. But equally, if one looks at the final assessment, there were also a number of references to positives. It's just that the red, amber, green system that's used, and it happens quite often, particularly with parents who have either learning difficulties or their own difficulties. You can have a whole number of ambers, but it's the pieces of the jigsaw together. Individually, they may not be significant, but putting together, they create a problem. And in this case, my submission is that on the evidence that was before the court, there were sufficient positives on behalf of the parents to say that it was arguable that they should be able to look after their child. And these were final hearing issues, not interim issues.
Yes, well,
that's the first.
You've made that point very clearly.
Yes. The difficulty I have to accept, my lords, is the balancing exercise that needed to take place. And I've tried to address that in my skeleton argument because although it was a limited hearing, His Honour Judge Thomas came back to on a number of occasions the local authority in the Guardian to be asked on what basis it was being said that it was necessary and proportionate to order separation at that point, and he just wasn't satisfied. So in a sense, if there is a criticism of the judge for not carrying out that exercise, equally, as you've heard today, more powerful arguments were put forward as to why he should. Now, the counter-argument is that we, at that hearing, there was a certain amount of time pressure, and the fact is, one of the issues in this case, to highlight, if I may say, my lords, is the pressures of dealing with interim hearings and the time factors. One of the central issues I would also raise in this court is the delay between the hearing, the report in August, hearing in September, and the issue then was the next hearing wasn't until October for a PTR. And the issue now for this hearing is because we don't have a hearing now until next April. And a number of the cases that have been referred to highlight the issues of delay. Some of them were before the protocol, and of course some after. But we are in a world now where delay is almost built in, sadly, to the cases that we deal with.
Yes, and that's a concern, obviously, but there's nothing that any of us here today can do about that.
No, well, we're all aware of that, my lord. So, my first argument would be to say that on the evidence, on the submissions that you've heard today, is that the appeal should not be allowed. But I hear very, very clearly the views that there is a strong case for this being remitted.
Well, can I ask you about? Let me put to you the same question I put to Mr. Prout. Suppose that we reach the conclusion that the judge's decision is flawed and therefore has to be set aside. Then, in principle, there are two alternatives available to this court, either to remit or to reconsider the matter ourselves. Now, in your submission, which of those two courses should we take?
My submission on the two would be to remit,
right,
my lord. My built-in reservation is, of course, twofold. Firstly, when it could be listed, and on what basis, because I did make the point, I think, in my skeleton, that the REC, the main one that we deal with, took 2 days of evidence. We don't live in that reality anymore. We don't have even live evidence. Can't remember the last time there was an interim hearing with evidence. It's always on submissions, usually for an hour. So if, with respect, my lords, that is your decision, it would need to be very carefully case managed today with a proper time estimate and the directions as to how and that hearing should proceed. You've heard this, I think my lord, you suggested in effect an update on the placement of the unit, or Mr. Froud did, and that would clearly be necessary, because you will hear that the current logs seem to be certainly positive as far as the parents are concerned, and they have said to us today they've already had some discussions over the weekend about the need for updating assessments as it's put to them. It may be they've misunderstood, as I'm not giving evidence for them, because there isn't a hearing till April. So either way, we're unlikely to get a hearing, I suspect, before Christmas. If it is remitted, it needs to be dealt with and very carefully case managed. And depending on that, some consideration today about what additional evidence may be required to make it an effective and fair final hearing in April. It's a long way off. The other point, if I may say respectfully, is that, of course, part of REC is that the onus is on the local authority to also provide the court with information as to what other resources may be available. No consideration has been given, or was given, to where or what should happen if there is interim separation. The plan is that the child will be placed separately to the parents. It does not mean, in my respectful submission, that just because this unit saying that it's negative, the local authority needs to bring it to an end, that there should be separation necessarily, that the duty is still on the local authority, I would submit, to consider what other alternatives they can come up, they can provide, suggest, to at least ensure that the mother and child are kept together. Now, I don't speak to the father, they come as a couple, but it would be quite a stark decision by any court toward a separation of the mother and child, a young child, so close to a final hearing, if that can be avoided.
Well, it would plainly be an option, wouldn't it?
Because
It would plainly be an option,
yes,
wouldn't it, for if the placement, the residential unit, were to come to an end because the court took the view, strictly speaking, the assessment had completed, the local authority could, if the court were to make other orders around time spent with the child by the mother, place the child back in a mother and baby foster placement, which is where they started life.
my lord, yes, and that's the point I made, because at the moment the plan is to find a foster to adopt placement.
Right.
Their plan is clearly
Something different.
set out,
Yes.
and that's what
I
the
understand
parents now face between now and the final hearing.
Yes. Thank you.
So, my lords, unless I can help you in any other specific matters, it's not covered in my skeleton or in the submissions that I've made.
No, thank you very much.
Much obliged, my lord. Thank you.
Yes.
Thank you, my lords. If I may just deal firstly with the point that was put to my learned friend as to whether this judge, His Honour Judge Thomas, would have been wrong in law had he, or for the indication he gave that the resources pertaining to the placement were not a consideration for him. I urge your lordships to step away from that particular point for a number of reasons. Firstly, it is a point that I would wish to research in a lot more detail in terms of legal authorities. Myself and Mr. Batt did locate, or I'm grateful to Mr. Batt, the case of FT, which is a decision from this court, which I appreciate is in slightly different factual circumstances, being at the start of an assessment rather than the end. But it does clearly say, unfortunately the decision itself isn't page referenced, but it does clearly say that there are two separate questions to be determined by a judge. The first is whether an expert assessment in the form of a placement should be directed. And if that question is answered in the negative, The second discrete and separate consideration is whether a child should be separated from a parent under an interim care order, and thus there the test set out in the case law is the test to be deployed. So some very basic looking into that point overnight flagged up that authority, but I would urge this court to be cautious because it's not a point that features in the grounds of appeal. It's not a point that I have been able to spend a lengthy time looking into. And perhaps more importantly, it's not a point that was raised before this judge. There are other manners in which the interplay or tensions between the provisions of Section 38(6), the ability of judges to oblige local authorities to provide certain provision for a child under an interim care order. There is a tension with the case law that also exists that says that judges have the assessment of risk, that local authorities are obliged to make work the assessment of risk that the judge decides, and that it's a separate question that the local authority, that the judge has to ask whether separation is indicated. There are other remedies available if a local authority decides not to take account of or to make work the assessment of risk. The injunctive relief of the High Court and to protect human rights and the right to family life does exist. So there are other remedies. I say it's a much more complicated question than that arises from the grounds of appeal. It may be a question that we all have to grapple with if you do decide to set aside this judgment and remit the matter for further consideration, or, as is always open to the local authority, if the local authority makes a further application in the court below, which has been open to it since the 16th of September. This local authority has declined to make any further application, and I say that is because the high justification that is demanded of applications to separate a parent and their child, particularly a young baby, at an interim stage requires a very high justification. And that's not there on the logs that we have now. I also say it wasn't necessarily there or at all when the matter came before His Honour Judge Thomas. And I also echo the submission made by Mr. Batt in respect of the responsibility of local authorities to put before the court all available resources that may exist to remove the need for separation. If I could also just touch on the point that was made about the 2020 Resi case, because...
just before you get on to that,
yes.
You touched on the question of remittal, and can I ask the same question I've asked Mr. Froud and Mr. Batt? Suppose that we get to the stage of deciding that the judge's decision was flawed and therefore has to be set aside, and therefore we are faced with a choice between remitting the matter and reconsidering it ourselves. Do I understand from what you've said already that you would be submitting that the correct way forward would be a remittal?
No, as per my skeleton argument, I say that you should affirm the decision of the lower court because the information that you have before you now,
right,
in terms of the placement logs.
And that's on the basis that it's not, your application to produce the further evidence is not opposed, and you say, at any rate, without additional evidence, we're in a position to make a decision ourselves.
Yes, because the key question, if a court is going to find that there is a high justification, the high justification is made out, is based on safety to the child. And not simply safety, it's where the child's physical safety or psychological or emotional welfare demands it. It's a very high bar, and the consequences of the separation must be a proportionate response to the risks. Mr. Froud has taken a pragmatic approach to the placement logs, and I don't propose to go into them in great detail at the moment. They are obviously not showing perfection on the part of the parents, but what they do show is a considerable improvement in terms of routine, feeding. This is a child who's tracking the centile. She is repeatedly referred to as a happy and content baby. And so what I say is whatever flaws are perhaps cherry-picked out by Mr. Froud.
Can I ask you this question? You seem to be inviting this court to set ourselves up as experts. Aren't the placement logs not in the nature of raw data, which should be subject to expert consideration?
That may be the case for a final hearing, but at interim stage, generally the court has to make do with what evidence it has. We frequently have reports from placements, we frequently have hearsay from social workers. It's the norm in the family court.
Well, I take your point entirely. The courts regularly have to do the best they can with the evidence available, absolutely. But as has already been pointed out, this case is slightly odd in that we have a final report by the expert as of the 12th of August, but we also have evidence that postdates that. Now, I fully understand, now you've clarified, and I'm grateful, that you say, well, we are in a position to consider that material, and you submit that it confirms the correctness of the judge's decision, even if the way in which he arrived at that decision was flawed. That I fully have got on board. But what's your response to the point that this is rather undermining the expert's completed assessment?
But the point that was made before Judge Thomas, and that he adopted and that I echo, is that the concerns raised in that parenting assessment, in fact, went to the long-term parenting of the child and not to an immediate risk to her safety or to her psychological or emotional welfare. And I say that this court can look at the placement logs and take a consideration as to whether this is a child that's presenting as one whose physical safety is at immediate risk, or whose emotional safety is at immediate risk. That's not borne out. She is recorded as being repeatedly a happy and content baby. There are regular logs about the parents providing attuned care, responding to emotional cues. Many of the matters that they were criticised for not doing in the parenting report, which I accept. But I say they go to long-term issues.
Ms. Ellis, the RISI 2019 decision provides us an extremely useful 5-point checklist, as it were. But do you agree with Mr. Froud that that's not the be-all and end-all of the test? That a court that's looking at a situation like this is concerned with the upbringing of a child, therefore Section 1.1, Section 1.3 is engaged, and that a court that's considering removal or separation needs to look at the wider perspective of welfare, having regard, of course, to Lord Justice Peter Jackson's 5-point test, and noting and applying the high degree of justification that's required to separate a child.
Yes.
But it requires a rather more panoramic view of the evidence, doesn't it?
I do and I don't agree with that. So my first point is that of course it does. The judge making a decision has to consider welfare. But I rely on the point I make about the Biglavska case, which is that when matters are so well known, which is particularly true when the matters in question are so well known, such as Section 1.1, such as Section 1.3, that judgments will always be better expressed. And on this application, it was for the local authority to make out its application.
Yes.
So the judge perhaps formed the view, as is clear from the transcript, that the local authority were in difficulty making that application out. He did press the local authority advocate as to where to find the material.
Yes. We might be at cross purposes because I wasn't so much considering that point, although you rightly say, of course, that Judge Thomas is an experienced judge. At least I take it that as to be the truth, if that's what you say about that. I don't know Judge Thomas. But I was really thinking more about your answer to my Lord Justice Arnold, that you considered that we should reconsider the decision, because if we're reconsidering the decision, surely we then need to undertake the wider welfare panoramic view in order to reach a proper, robust, informed welfare decision? And if so, do we have the relevant evidence for that?
Well, of course, firstly, you have to allow the appeal if you're going to be invited to affirm the decision. And I obviously oppose that. But I do say that the updated information, the information that the local authority would rely on in support of any application, would be the on-the-ground monitoring of the parents and the child in the placement. So in my submission, it would be available to this court to look at that evidence, to analyse it, or to simply take it at face value, I would say, and say, well, in fact, there isn't evidence here of this child suffering significant harm at the moment.
Out of interest, would there be any expectation that your client would file any evidence on such an application if it were to be remitted?
If directed, quite often on an interim care order
I
application.
wasn't asking about directed, it was expected. I mean, would your client, you see, we've been taken in the logs to one or two comments about things that your client has said and done, and he might well want to respond to those as a matter of evidence.
Yes, he may well do. I haven't taken those instructions, and I could do over the lunch in adjournment.
But my question really is, would, recognising as I do that he conducts this litigation through a litigation friend, would it be your expectation that he would or wouldn't file evidence or have evidence filed on his behalf to deal with points that he may wish to challenge?
Well, I would say that the evidence that we have at the moment without his evidence doesn't meet the high justification. And so, in fact, my client shouldn't need to, but may consider it prudent to do so and to put his position on certain matters before the court. Because the factors that the court should be looking at when deciding whether to separate a child from, a particularly young baby, from its parents, are the impact on the child. And I say that the placement logs don't bear out that there is that significant impact on the child that one would expect to see in order to consider that her safety, physical, emotional, psychological, demands that separation, and the impacts that we know happen to babies who are separated from primary caregivers at a young age before issues of dispute can be dealt with at a final hearing.
Can I just ask about the interplay if we were asked to remake the decision and the section 38(6) point? Do you go so far as to say there's no evidence of, or no sufficient evidence of immediate risk, harm to the child, if the child was not guaranteed to be stay in the placement?
I don't go that far today. No. I would need to give that more consideration.
So you would need to ask us to assume, as the judge did, that placement would continue?
Well, you haven't been given any indication to the contrary by the local authority at this stage. And I would say that if the local authority wanted to mount an application to separate and discharge section 38(6) and go down that legal avenue, that ought to really be a fresh application to the first instance court. I'm not going to push too hard for this court to affirm the decision if it doesn't feel that it is in possession of all the available material. But I would say that when one looks at the overriding objective, there is material here. I say that would show that the separation argument isn't made out on the way it was put by the local authority at the original hearing. I don't think I can take it any further than that.
Thank you.
But I would like to address, if possible, the points that were made when Mr. Froud was making his submissions about the secondary C case, the 2020 case. Now, that wasn't put before Judge Thomas, which is unfortunate. But I just want to flag that a couple of times the interventions from your lordships have referred to the decision being flawed, and you may have to set aside the decision if it is flawed.
If of course, we understand that both you and Mr. Batt say there's no flaw in the decision. On the contrary, it was unimpeachable.
Of course, but I also take issue with the word flawed, because what paragraph 12 of Re C, the 2020 case says, and that's at page 17 of the authorities bundle, it says, unless his or her conclusion is shown to be wrong because evidence has been ignored or misunderstood or evaluated and weighed up so inadequately that the conclusion is perverse, this court will not interfere. And in my submission, there is some distance between flawed and perverse. And really, because this is an interim decision, because this is a discretionary decision, and it is one that is carried out by a judge that knew the case, knew the child, knew the parent, knew the evidence, this court ought to be at its most benign. I refer to that in my skeleton argument. And really, it should be, well, yes, perverse, extremely wrong for this court to interfere.
Well, can I just ask you about that? Of course, I take your point that we must take care to give the judge's decision appropriate deference. That's undoubtedly so. But to what extent had the judge been previously involved? Because, I mean, for example, we've been handed up in the course of the hearing to the earlier orders. So we have the order of District Judge Whitfield that my Lord had asked for on the 22nd of April, and before that the order of Judge Scarrett on the 8th of April. So this doesn't seem to be in a case where there's been judicial continuity.
I apologise, Mr. Batt's just corrected me. That's an incorrect submission on my behalf.
Right.
So it's right.
Thank you.
I'm sorry, just to picking up your point about perverse, which has caught my attention. What Lord Justice Peter Jackson goes on to say is why this is so was explained by Lord Wilson, and he then quotes the passage from Re B. Does Lord Wilson use the word perverse? I didn't see it.
No, but what he does say is, what does this evidence tell me about any future parenting of the child in a public law case, when always hoping to able to answer the question negatively, to ask, are the local authorities' concerns about the future parenting of the child by this witness justified? And it demands a high degree of wisdom on the part of the family judge, focus training, and allowance to him by the justice system of time to reflect and choose the optimum expression of reasons.
Yeah.
And the corollary is the difficulty of mounting a successful appeal against the judge's decision for the future arrangements for a child.
Yeah.
Obviously, that was a final hearing case.
Yes.
And we're at interim stage. I would say that at an interim stage, one has to be even more cautious about interfering with discretionary decisions of a first instance judge.
Provided that, I assume you would say, the judge has properly evaluated and balanced up the factors relevant to the child's welfare, which is how Lord Justice Peter Jackson opens that paragraph.
Yes.
Yes.
And I would say that this judge has. I have set out in my skeleton where I say he did so. He did so very briefly. But this is a judge who was fitting in an urgent hearing, or I say it was an urgent hearing, it was actually missing for some time, but a short hearing in what is likely to have been a full list, or perhaps slotted in during a trial, which is the reality of life in the family court that we all appear in. And what the judge did do was he asked the local authority advocate repeatedly where the evidence was. And what I say is, if there was a concern that certain documents hadn't been read, that was the point in which the advocate should say, well, it's in this document, this paragraph, and if the judge says, well, I haven't seen that, then you say, please could you put the matter back to read the document that I say evidences the submission I'm making. None of that occurred, but I would say the reason that local authority advocate on that occasion didn't make those submissions is because there wasn't anything in the additional evidence that the local authority rely on now. And it's telling that even when pressed by your lordship, Mr. Froud did not flag any parts of the witness evidence from the local authority as supporting the points he makes on appeal. The page reference you were taken to were page references of the report that the judge had been clear that he had read. And I say that the witness statement of the local authority dated the 19th, I think it's referred to in the index as the 20th, but I think it is dated the 19th of August, did not rely on any new matters that had occurred since the date of the final report. So there wasn't anything in that material that could assist the judge. But even had there been, the advocate was given the opportunity to draw it to the judge's attention, and I say they didn't because they couldn't. Complaint is made by Mr. Froud that the local authority advocate wasn't able to expand their submission sufficiently enough. I say that's not made out by the transcript. there are pages of discourse between the judge and the local authority advocate where he asks her where the evidence is. And it's right that Ms McGrath, on behalf of the Guardian, was given a little more of a free rein to give a full narrative. I say the local authority is in difficulty praying that in aid because, in fact, the Guardian was supporting their application. So, in fact, Ms McGrath's detailed submissions simply added to the submissions made by the local authority as to why the Guardian was saying that separation was justified. And I've dealt in my skeleton argument with how I say the judge dealt with those matters raised on behalf of the Guardian, and that's at paragraph 34. And we can see it from 58 of the core bundle onwards. The matters raised by Ms McGrath quite properly were the hospital admissions. Those had occurred as far back as June. I think the last discharge was on the 2nd of July, and the safeguarding referral that was referred to occurred on that date. It was made directly to the social worker, and it didn't trouble the social worker sufficiently to be included as a reason why separation was justified. Ms McGrath raised the Guardian's concern that the child was being parented by the supervisors. Whether that's justified or not, it's a submission the judge was entitled to take as one that informed him that the child was receiving safe care, involving other people, not her parents, and if the intervention doesn't happen, the child will suffer harm. I say doesn't consider the reality of the child's situation, namely that she was in a protected environment, and this judge didn't have any indication from any party that that protected environment was going to come to an end. So I've dealt with what I say about the Guardian submissions. The judge said that he felt there were final hearing issues, and he felt that the local authority and Guardian hadn't properly applied the factors in Re C. My lords, I've gone rather out of turn in terms of the grounds, but really my opposition to this appeal is fairly global on behalf of the father through the OS, which is that you should be extremely cautious in terms of interfering with this decision. We have evidence that the child does not appear from the logs suffered harm, certainly not at the level that one might expect to see. And really that's evidenced, although you are not experts, it's evidenced by the fact that the local authority haven't returned it to court, and by the passage of time. We are now in December. This hearing was in September. It was applied for in August, and the report from the placement is also dated in August. This is simply not a child that's been suffering harm that would demand her separation from her parents and demand that extreme step that can have really significant consequences for the conduct of proceedings, for parents trying to run their cases at final hearing, that makes it difficult. Just touching on ground 3 of the local authority's skeleton argument, obviously the skeleton argument was prepared, not by Mr. Froud, and prepared before the transcript was available, but I say it's not made out by the transcript. The transcript clearly shows the judge kept asking the advocate what emotional and psychological harm there was evidence, and none was brought to his attention. Is there anything else that I can assist your lordships with?
Just one point of information again. I noted, I've obviously read the transcript and I've seen the judgment, and I can see how counsel, I think it was, who represented your client at the hearing made a very limited intervention because he frankly wasn't encouraged to make much. Yes. But I noted from the order that he was described as being neutral on the application for separation. Was that an accurate recording of his position? My
understanding is that the official solicitor at the time was neutral on the application.
I see.
Yes. But since then, and since considering the placement logs,
right,
the official solicitor has taken a different approach on this appeal.
I see, thank you. Thank you very much. That's all I raised.
Actually, I'm so sorry, there was a point I just wanted to raise about the order.
Yes.
Because you made a comment, Your Lordship, about the order not describing the care plan and other matters. Orders are always drafted by counsel. They're not in the family court. The judges simply do not have time to draft their own orders. If they are agreed, they are sent to the judge for approval. I can't comment on what that process entails with approval, but certainly it would have been drafted with the input of all council.
Thank you. Thank you very much.
Yes.
My Lord, thank you. On behalf of the Guardian, I of course echo and endorse the submissions made on behalf of the local authority, and I will do my best not to repeat submissions that have already been put before you. I think it's important to first of all comment on the hearing itself and some of the aspects about how the day transpired, or rather the morning. As we were walking into court, it was the understanding of all of the parties, I believe, that the assessment was going to be terminated because the assessment was at its conclusion. There was no discussion outside of court, beyond literally walking into court, regarding what was going to happen with that assessment, and it had been the understanding of the advocate, certainly, that the assessment unit were serving notice on it because it had concluded. It was only when we were in court and the judge started to raise the issues as he did that it became apparent that the unit were willing to keep the family in the placement. So there was no opportunity for any of the advocates to give proper consideration to the implications of that change of position by the unit. It's also right to say that it had been the position of the parents that they did not want to stay in the unit anymore. And certainly that had been the indication given to the Guardian in her very recent meeting with the parents, that they were done with it, they didn't want to be assessed anymore, they didn't want to be in the unit, and they were going to leave.
Right, just a point of detail there. You say the parents.
The mother.
Yeah, just wanted to check because the judge refers to the fact that the mother had filed a position statement, or had a position statement filed on her behalf in which she said, "I'm unhappy here, I want to leave." Had the father done the same or not?
No, it was very much the mother's position,
mother's
and that was also expressed to the Guardian in her meeting. So in terms of how those issues were then put to the court and considered, they were very much ad hoc because it was in the moment that we were told that the unit were going to be willing to keep them. There wasn't an opportunity for the local authority, I would submit, to consider the consequences of that in terms of finances, and it was very clear and is clear in the judgment that the learned judge had made the assumption that if he thought that that was the way forward, then that is what was going to happen, and that is the way that the case then progressed. And I do say, and I accept that I did not put it to the court in terms of the Section 38(6) argument and that assessment having concluded, but I did raise the issue in a more general sense. And Your Lordship, you'll see that the judge immediately dismissed that as a concern and immediately returned to the REC argument that you've already heard submissions in relation to. I think it's also important to make the point in relation to those submissions made on behalf of the father in terms of the Local Authorities Council being given an opportunity to make submissions. What you can't see from a judgment is the amount of time between the question and answer. There was no time given to the local authority to respond, even though the question was put. And that was very clear to any advocate that was present on the day. I, of course, did have an opportunity of making more detailed submissions than the local authority. And I don't accept the submissions made on behalf of the parents and indeed his learned judge that the submissions made on behalf of the Guardian were focused on long-term events. I think that was a mischaracterisation of the submissions made because I think it's clear from the transcript that all of the submissions made on behalf of the Guardian were due to the concerns for what is happening on the ground on a day-to-day basis for this child. It seems from the judgment that His Honour simply took a very simplistic view of the report, and because there wasn't a sentence that said this child needs to leave this unit, otherwise X catastrophe will happen, he took the view that there wasn't the evidence there. But I say that he was flawed in that, and had he undertaken the analysis that he should have undertaken, any reasonable reading of the report from the residential unit demonstrates very serious concerns for this child on a day-to-day basis. And what I say the lower court didn't do was separate physical and emotional harm in the context even of my submissions. There are certainly aspects of potential physical harm with the hospital. There was also 2 incidents of the staff having to literally run into the room because they found the child to be asleep with a cloth over her face. And on one occasion, the parents were asleep as well. So there were numerous incidents, had the judge read and considered and analysed the report properly, that demonstrated that there was risk of physical harm. But alongside that, the Guardian was making submissions in relation to the emotional harm elements that are separate. And I was very clear with His Honour during that hearing that a child of this age who is not receiving attuned care by their caregivers is going to be suffering emotional harm. And I say that the judge incorrectly said that that's a long-term issue, that is a matter for the final hearing, when the Guardian was very clear that that was an issue for now and every day between now and the final hearing.
We see that at 61, don't we? Guardian's very clear this isn't about her physical needs and emotional needs. Because she's being supervised, she's a young person that deserves attuned, nurturing care, and she's not getting it at the moment.
Absolutely, my lord, yes. The judge was very clear, and I think it's important to understand that the reason the submissions were being made in the way that they were was that whilst there's references within the transcript to the judge mentioning physical and emotional harm or psychological harm, the emphasis was very much on the physical harm. It was, where in this report am I going to see that this child is going to suffer imminent risk now, essentially? And therefore the submissions were very much guided in that direction. But the Guardian was still clear that there was both physical and emotional harm on an ongoing basis for this child while she remains in this placement. And the Guardian, as I have indicated already, did reflect also on the resource issue. And I say that had the court engaged in a proper discourse about that, the issue of the Section 38(6) would have been appropriately covered, but he was so dismissive of it. I was left in a position where I was expected to essentially defend the Guardian's analysis of risk, rather than also focus on that point that I say was relevant and is relevant today. My Lords, in terms of whether this matter should be remitted or reconsidered at this stage, the Guardian overall is neutral in that she's very concerned about delay. She continues to be concerned about this child's physical and emotional safety in the placement, but she also recognises that we do now have these updating logs, and it may be necessary for the lower court to reconsider the impact of those and what evidential value they should have when considering what should happen for this child now. The Guardian's reading of those logs are that she is not, her position doesn't change. Those logs are not assessment logs. They are simply pointing out day-to-day aspects of what is happening for this child. There is no analysis in the logs of what that means for this child's physical and emotional safety. And that's significant. The Guardian also thinks this process has been incredibly unfair on the parents. Whilst, of course, our focus is this child, this process has left the parents in a limbo land, and it is very difficult for them being here today, having to hear these arguments again and not knowing what the future is going to be. The Guardian is very aware of that, but of course the child is her priority.
I'm pleased to hear you making that point, because although we are focused inevitably on the child, the parents also deserves the court's consideration. So I'm grateful to you for making that point. But when you say the process has been unfair on the parents, that's a matter obviously of regret for this court. And I wonder, are you able to enlighten us as to how you think that has come about? And are there lessons we can learn?
My Lords, I think, first of all, with the judge of first instance not undertaking a proper analysis of the risk and therefore making a decision that was flawed and the wrong decision for this child, that was clearly the starting point. Delays, of course, have been very significant, and it's unfortunate that there was 3 weeks with the lower court judge having to consider this very short judgment. But I do understand that that's within a very busy court day, so I make no particular criticism in relation to that, but of course it's regretful. The fact that they are now in a position where they feel that they're doing okay because they haven't been being assessed, they haven't been having the proper feedback that one would anticipate during an assessment process. So nobody has been having those weekly interventions with them, telling them what they could or should do better.
Am I right in understanding that that's because the assessment is complete?
Absolutely, my Lord, yes. So they've been left in a very confusing position, and that has also led to confusion really across the bar in terms of the way forward. The family have been left in a very difficult position, and it's incredibly unfortunate. And I say, overall, I echo the local authority's position that had his learned judge undertaken the proper analysis that is expected on welfare and risk and harm, this decision wouldn't have been made. It's because the judge took a very simplistic view of certain aspects of that report, took one sentence from one section, I'm talking about paragraph 12, he looked at the amber issues and said, oh, okay, so they could learn some more. And he really put all of his weight behind that one sentence, when had he looked at the report as a whole, had he focused on the red section and looked at that report and those comments in context, he would have realised that the decision was flawed. But it's because he didn't do that analysis that he didn't reach the right conclusion.
Well, he does look at the red section, paragraph 7 tells us that, but he seems to mitigate the impact of the red section by simply saying, well, the parents are remaining in a structured and protected environment, so that in a sense means that the child will be sufficiently safe even though these red factors have been identified.
My Lord, yes.
That's as I read what he says in paragraph 7.
Yes, he references the red section.
He does, yeah.
But had he undertaken a proper analysis of what the red section says, he wouldn't have felt that it was appropriate for this child to remain in this placement with the support that was in place for them. Because even with the support, this child is suffering harm on a daily basis. And that's where I say there was a mistake on his part. He doesn't look at the detail of that red section and think about what does that actually mean in terms of day-to-day risk. And because that analysis is missing, he reaches the wrong conclusion.
Thank you. I'll just explore the relationship between the risk of harm and the fact that support continues to be provided. And I see a distinction between emotional harm and physical harm, in that I think you would say that the emotional harm is being suffered irrespective of the fact that there's support being provided by the facility. Is that right?
Yes, my Lord.
As to the physical harm, at least some of the instances relied on in the social worker report and the final report were when one-to-one support had been taken away, taken away, and it was reinstated. So those risks would have, the judge can be justified, I think, in saying, well, those risks are catered for. 2 questions. To what extent is that right? And secondly, am I right in assuming that that one-to-one support that was reinstated is carrying on, notwithstanding that the assessment has ended?
My Lord, yes. In relation to the first point, I think that for the feeding aspects, certainly the reintroduction of close supervision will have had some impact on that,
although you will have read that there was some resistance by the mother to the residential unit workers trying to reinforce protection in those areas. But where I say the court was wrong in relation to the physical aspects, with the blanket over the face, if there isn't a member of staff watching the monitor at that time, and of course they are monitoring several families, not just this family, something catastrophic could happen. And it would be because of human error, but it shouldn't be the situation that this child is left with parents who aren't able to identify those very significant risks and are relying on others. So I say that to a degree the physical risk still applies, and had the court really thought about that in his analysis, he may very well have taken a different view. In relation to the emotional harm, then yes, absolutely, that is happening on a day-to-day basis because of lack of attuned care, and that cannot be corrected by any level of supervision. My understanding is that the supervision is back at where it was prior to the intervention. The conversation between the front of the bar is in relation to that supervision, because I think it was suggested this morning by the father that some of that supervision had been withdrawn, but my understanding from the local authority is that it had not. So it may be for the local authority to answer that question, and forgive me that I don't have a direct answer to that. But certainly from the Guardian's understanding in recent meetings that she has attended, the supervision is at a level that she says is required in order to keep this child safe. My Lords, are there any specific points that I can assist you with? I risk going over submissions made on behalf of the local authority.
No, thank you very much.
I'm grateful.
So, Mr. Froud, any reply?
My Lord, not in response to any of the matters raised. I've dealt with the matters as they've gone along, and I certainly hope the court's taken those from the written documents. Just on that last point, I am taking some instructions from the social work team. The conversation that I believe my learned friend was referring to was in relation to a request that I had this morning, which was to take instructions on whether or not the unit were proposing further assessment, because that was what the parents had instructed their legal representatives. I have taken instructions on that point, and we are told by the home manager that that conversation did not take place. So that is the conversation I believe my learned friend is referring to. I'm taking instructions on the supervision point. However, even without knowing the substance of those instructions, the unit is one which requires 24 hours a day CCTV supervision. So the extra supervision which my learned friend has referred to is that which is required, for example, when doing feeding, changing, bathing, and a member of staff accompanies the parents directly doing so. And I'm just checking whether that remains in place or whether it's, I say simply, but it's still an intrusion, simply the video surveillance. If I may just have one moment, please, my Lord.
Certainly.
I understand from the social worker that the supervision has reduced, but it is still one-to-one when undertaking certain tasks. I can't go through every single one of those, I'm afraid, my Lords, for the purposes of this hearing. But
No, and that's not necessary. So we're grateful for the clarification that you've been able to give us.
I'm grateful. My Lords, are there any further matters which have been raised by my learned friends during the course of submissions with which I can assist?
No, thank you very much. Well, thank you to all the advocates for impressively concise submissions. We will rise to consider the way forward.
would like to also get some fresh air. Miss Ellis. Pardon? Okay, very well. Thank you.
Let the parents,
But just to let you guys know, it's really nice.
yeah, the parents might want to pop out to the loo. That's all.
If you
Just
need
check.
the toilet, feel free to pop out. I think it's only going to be 5 minutes, so you might want to just wait. If you could step outside the corridor if you need a break. Like, once you do that.
Don't go outside the building. Don't go